The federal rules of evidence generally don't admit character evidence, but do admit habit evidence. But how is a character trait any different from a habit? The 11th Circuit considered this question in Loughan v. Firestone Tire and Rubber Company. On July 4, 1974, mechanic John Loughan reassembled the parts of a Firestone rim wheel. While he was installing the wheel onto a trailer axle, the wheel parts separated with great force, hitting his head. Loughan then sued Firestone for strict products liability in federal district court. He asserted that a design defect caused the parts to separate. Firestone argued that Loughan reassembled the wheel incorrectly because he'd been drinking alcohol that day. To prove this, Firestone sought to admit evidence that Loughan had a habit of drinking at work. Specifically, during depositions, Loughan's previous employer testified that he fired Loughan because he drank at work throughout his employment from 1969 to 1971. Also, Loughan's current supervisor testified that he routinely brought a beer cooler to work and drank during work hours throughout his employment from 1971 through 1974. Loughan himself admitted to this behavior but denied drinking on the day of the accident. Loughan argued that all the deposition testimonies were inadmissible character evidence. The judge found that Loughan's drinking was consistent enough to be a habit and admitted the testimony under Federal Rule of Evidence 406. Ultimately, the jury found for Firestone, and Loughan appealed to the 11th Circuit.